Dr. Singhvi, the problem with your argument is very simple.
Private and...
If your argument is right,
yes,
that would mean that wherever a contract is a statutory contract,
yes,
that it is a contract within the fold of a statute, not just regulated by a contract, but there are statutory contracts. Then any payment which is made under the statutory contract becomes in the nature of a tax. We'll have to go as far as
no,
that.
you should not have to. Give me a...
Comes down to that.
No, it will not have to. I assure my lords. Your lordship will have two considerations which fell in the open argument which I was hearing earlier. One, if it's a tax, how do private people collect royalty? That was one argument against which I am answering in a minute. The second is royalty is not a tax, it's a share or a consideration. The judgment from the Saurashtra, Gujarat. These two I'll answer in a minute. You should be satisfied. I've dealt with it. But first, I'm on the elements of a taxation, which McDowell...
The license which is paid,
yes,
for the state to partake, or for the state to pass with the privilege of selling alcohol or liquor, it becomes a tax. It's not a license fee by this.
Well, if it's a statutory contract...
Because the state parts with the privilege to deal in liquor.
Yes.
Right?
Yes.
You pay a royalty, you pay a license fee.
I'm going to say it's a tax.
It's a tax.
No, I'm not saying it's a tax. If your lordship has... See, contracts, ultimately, under the law, are contracts, whether they are under the fold of a statute or otherwise. So there will be consenting parties with a contract to which I cannot argue then that that's a tax. I'm going to say it's a contractual fee. There is no contradiction in my argument. Whereas it will remain a contractual, consensual payment. Somebody will pay 10, somebody will pay 20, longer term, lesser term. It is contractual, it is not tax. The real only two questions against me on this section are the private person collecting royalty, which I'll demonstrate in a minute why it's a wrong argument, and the Saurashtra High Court judgment. I'll deal with them in a minute. So first your lordship has got B5 at page 326. Yes. Clearly the characteristics of a tax are satisfied, absent those two contra points which I'm coming to. Now on this, my conclusions, if your lordship doesn't mind. Now, I come to the other contra point. If it is a tax, Mr. Singhvi, how do private persons collect it? Very simple answer, Let me give the answer first and I'll read the rule. Well, it is true that it is a relic of the constitutional past. But the tail should not be allowed to wag the dog, as was mentioned yesterday. This will be a case of tail wagging the dog. It is a very, very few number of states, and my learned friend relies on Theresima, Mr. Devedi cited it, which was Kerala, which had forgotten, I will use the word forgotten, to pass a law saying that the mineral under the earth is the states. Incidentally, after Theresima, Kerala immediately passed that law. Most other states, 99% have that law. It is true that there may be one or two examples, which I call a tail malice, that will not decide a 9 judges approach. That royalty is not a tax because 0.1% cases may be there in the country where the mineral does not vest in the government and therefore there can be a private lease for which royalty is paid. That's answer number one. Answer number two is very interesting, Willis, is that even in those private lease cases, the 2016 rules make it clear that it is completely controlled by the government. Because the private man, he's the private lease owner, he can't give me a lease. He has to go through a gamut of prior authorization by the government under 2016 rules, which I'll show in a minute. And the third reason is most important. This private leaseholder cannot enforce through 25. That's the hallmark of a sovereignty of a tax. So,
what is the third reason?
Third is this private fellow who has a relic, a few occasional leases here and there in the country which have not been taken over by the government, cannot use 25 to enforce. The enforceability is given only to the exaction. Section 25 is clear. There was an absence at that time of a provision in the Kerala land revenue declaring the ownership of minerals underneath to vest with the state. That is one of those anachronisms. There is hardly a place, 99% would not be that. It's a relic of the pre-constitution position which I have said. But your lordship has that book.
Yes.
It's got the 2016 rules, which says for a private owner of a lease to even negotiate with him and give it to him, everything is covered by prior permission and authorization. He can't. And this is true of minerals other than hydrocarbons and atomic. In hydrocarbon and atomic, of course, there's no question. It is already gone with the state. But for all other minerals, every other mineral. So, Manas, it is a relic. It's an argument used to decide the main matter where 99% leases are not there and lordship is, it is true factually. I can't deny it. But Manas, it just doesn't make sense to interpret it on that basis, my humble submission. Now, Manas, that's the 2 points. And lastly, Manas, as I finish my first proposition, just see that 4 months later judgment by the same learned judge who presided over India Cements and how he understood tax. Kindly see the Honorable Chief Justice. And Manas, I will always hearken back to that question. What is so specially wrong about India Cements or what is so specially correct about Kesharam?
Which part is that?
Para 6 at page 67. That this entire established law should be changed.
Months after the.
I'm sorry, not 4 months, 2 months after India Cements. 2 months after India Cements. Well, all this is happening because a 5-judge bench, at least judicially, Manas, has set the cat amongst the pigeons. Unless there's some overwhelming reason why a lordship should not follow a 5-judge bench. Otherwise, the law was very clear, understood as clear. Dead rent is the second proposition. At page 335, it starts. Is clearly even a fortiori a tax. As a lordship knows, the scheme is central government occupies in 9 the royalty. In 9A, it starts occupying the dead rent. Well, I would like to call a dead rent an idling charge.
It is made to the government. Will a minimum guarantee payment also partake the character of a tax? Because in a large number of situations,
Yes.
a minimum guarantee payment is assured to the government, whether it's an electricity company. Where the principle is you must lift electricity.
No, answer is very simple. I appreciate my lord's question. It's very important. Nobody can say a minimum guarantee.
Suppose there's a public-private partnership. Government has once an assurance of a minimum revenue. It says you must give me this, irrespective of what profits you make.
Straight away. There's no problem. Every example which your lordship has in mind will be contractual. Every example. What are these public PPPs, Manas? One is a BOT highway. Second is a tender. Third is an auction. All contractual. This is, Manas, an exaction under 9A. Your lordship has a clear dividing line and I am not going to be inconsistent, Manas. I've just yet to show your lordship a very interesting statement of objects and reasons when 9A was brought in. Your lordship will be shocked. Every case will fall in the contractual versus the non-contractual exaction line. And that's why 366/28 is perfect. Chief Justice Latham is perfect in Chickering. Followed by, Manas, 1 9 judge and 1 7 judge in India. Shirur Math and Jindal. Now in this, Manas, dead rent, first of all, the points are the same, Manas. 3 elements: compulsory, non-voluntary, exaction, and Manas, enforceability. Same. Here the additional point is, it is not based on what you extract.
Nature of a tax.
As a matter of fact, the better way of looking at dead rent is it's a charge on you taxation for squatting or for Manas, idling. You just idle. Either, Manas, my learned friend Tushar Mehta gave a reverse example. I would think the better example is that you sit and do nothing. He gave an example that you overexploit early. Suppose you do nothing. You are depriving this man from getting it. You are not contributing to the country and you are sitting idling. So dead rent comes in. Irrespective of whether you extract or not. This is the Indian Bureau of Mines, which is the Manas, mother organization for all this. Royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366/28. Linked either directly or indirectly to the intrinsic economic value of a mineral realized through sale by the lessee. Royalty on mines cannot be a fee, but a levy in the nature of the tax. Royalty on coal is a tax. Your lordship has taxes which are royalty under 9. This lordship I have not put here, lordship I want to note on the side of B25. Royalty is a tax under 9. Dead rent is a tax under 9A. DMF is under 9B. Only thing which I get a quid pro quo and a benefit is the fourth one, NMET, the exploration tax. That is 9C. That can go in the category of fee, but it's an impost covered under 366. It's the fifth one which came in 2015 in my B25 para, which is a bidding parameter. That is contractual. That is not a tax. This what happens is, Manas, after the auction regime of 2015, I have to bid. So I bid 10 rupees, he bids 20 rupees. On that bid of mine, depending on the bid, I have to give a share. That's my contractual thing. That's the fifth one which has come only in 2015, which I have quoted in B25. All the other are compulsory exactions. I'm only contrasting it. It's called a premium, but it's actually a contractual exaction, a contractual payment. And that is the closest to a share or a consideration. I'm contrasting it, brothers. Now, brothers, the first point I wish to take your lordships to is royalty is a tax. And I've broken it up, brothers. I'll be reading less than half of these paras, but lordship will allow me to go in my sequence in that. Brothers, what are the elements of my first proposition? Royalty is a tax. The elements are: number one, your lordships cannot ignore and must not ignore 366(28). It's a constitutional provision. The elements are that your lordship has an inclusive, which means an expensive definition of tax. In a sense, tax proper and akin to taxes or deemed to be taxes, which are imposts. The characteristics are given in my B3, page 325. Tax or impost, general, local or special. So it's an inclusive, expansive approach. I've given a list of your lordship starting from Shirur Mat, 7 judges. All of them reiterate the famous dictum of a tax by Chief Justice Latham, which is my first para. All of them. I ask myself, which is the element of this missing? None. Is it compulsory? Answer yes. Is it public authority? And most important, enforceable by law. I know a lordship has two queries. One is royalty is not a tax, it's a share or a consideration. Second is it's charged by private persons. Please leave it for 2 minutes, I'll deal with both of them.
Yes.
Under 366(20), but this is a constitutional article, how can it be ignored? 366(28). Taxation has been defined to include the imposition of any tax or impost, whether general or local. Impost means compulsory levy, non-volitional, not optional. The well-known and well-settled characteristics of tax in its wider sense includes all imposts. Impost means 1, incident of sovereignty. 2, law means an act of legislature. We know 265 very well, Malas. The term tax under 265 includes imposts of every kind, tax, duty, cess or fees. And the idea of 360(28) is to be expansive and inclusive, not restrictive.